His parents had $900,000 total estate, a paid off home, savings, a life insurance policy. They sat him down at the kitchen table and told him the plan. We've worked our whole lives for this. We want to make sure you and your sister are taken care of. When both parents passed away, Michael and his sister received $60,000 between them. The $900,000 was gone, every dollar of it. And here's what nobody tells you. Nothing went wrong. Nobody made a mistake. Nobody got sick with the wrong disease or lived too long. The money disappeared because of three completely predictable, completely avoidable things that almost nobody plans for. And I'm going to show you exactly what those three things are, and I'm going to show you what it looks like when a family gets it right. Hi, I'm Chuck Roulet. I'm an estate and elder law attorney licensed in both Florida and Minnesota, and I've been helping families protect their inheritances for nearly 30 years. And if this video is useful to you, hit subscribe. I put out a new one every week. Now, there are three forces that erode an inheritance, and most families only know about one of them. Number one is long-term care costs. And this is the single biggest threat and the one nobody talks about at the kitchen table. Number two, probate. Slower, more public, and more expensive than almost everyone expects. And number three, income taxes on inherited retirement accounts. A law changed in 2020 that most families have no idea about. So let's go through each one. So long-term care costs are the inheritance killer nobody puts in their financial plan. Right now, a private room in a nursing home or memory care facility runs $120,000 to $180,000 per year. Now, here's the number that changes everything. The average person with Alzheimer's lives 8 to 10 years after diagnosis. The last 3 to 5 years of that journey almost always require full-time residential care. And at $150,000 a year for 5 years, that's $750,000. That is most families' entire inheritance gone before anyone gets a dollar. And here's the assumption that makes this so much worse. Most people believe Medicare will cover it. Medicare does not cover long-term custodial care. Medicare covers short-term skilled care, recovering from surgery, a hospital stay. It covers the first 20 days in a skilled nursing facility, applies a copay from day 21 to day 100, and then stops entirely. For years of memory care, it provides essentially nothing. The cost falls entirely on the family. Now, Medicaid will pay for long-term care, but qualifying for Medicaid means spending down most of your assets first. And even after that, there's Medicaid estate recovery. After your parent passes away, the state can file a claim against their estate to recover what Medicaid paid for care. The family home, well, that's the one asset most parents think of as the centerpiece of their children's inheritance. Well, the family home can be required to be sold to repay Medicaid after you've passed away. And this is what happened to Michael's family, not because they were careless, but because nobody told them this was coming. Now, most people know probate is something to avoid. Now, very few people know how much it actually costs. In Florida, guidelines for attorney's fees for probate are set by state statute, and they're based on the gross value of the estate, not what's left after debts. And that's 3% on the first million. So here's what that means in practice. On an estate with a $400,000 home and $200,000 in savings, the statutory attorney fee alone is $18,000. If the personal representative takes a fee, which they are also entitled to by statute, that's another $18,000. Add court costs, accounting fees, and other expenses, and a straightforward Florida probate on a modest estate can cost $25,000 to $45,000. And it does not just cost money, it takes time. A Florida probate routinely can take several months to a year or more. And during that period, the assets may be tied up. It means your family can't access them. The estate can't be distributed, and everything sits in legal limbo while you work through the court process. There's also something most families do not think about until it's too late. Probate is public record. Anyone, a neighbor, a creditor, a distant relative, can look up exactly what your parent owned and exactly who got it. Now, none of this is inevitable. Assets held in a properly funded revocable living trust pass to beneficiaries without probate, privately, quickly, and at a fraction of the cost. Assets with beneficiary designations, life insurance, retirement accounts, pay on death bank accounts, also pass outside probate. Probate is a planning failure, and it is almost always preventable. Now, the third inheritance killer is one that most families and even many financial advisors underestimate. When you inherit a traditional IRA, a 401k, or another pre-tax retirement account from a parent, you do not just inherit the money, you also inherit the tax bill. Every dollar you withdraw from that inherited account is taxable as ordinary income. And since 2020, thanks to a law called the Secure Act, most adult children who inherit an IRA must fully withdraw the entire account within 10 years of the parent's death. Now, the old strategy called the stretch IRA, where you could take small distributions over your own lifetime and let the rest grow tax deferred for decades, well, that's now gone for most people. So here's what this looks like in real dollars. Your parent leaves you $300,000 in an IRA. You're 52 years old, you're working, and you're in the 24% federal tax bracket. And this is not even counting in state income taxes. You must withdraw the full account within 10 years. Spread evenly, that is $30,000 per year added to your existing income. By the time federal and state taxes are paid on every distribution, that $300,000 inheritance may net you $195,000 to maybe $225,000. So between $75,000 and $105,000 goes to the IRS, not because of poor investment performance, not because of fees, because of a law most families have never heard of. Now, there are strategies to address this. Roth conversions during the parent's lifetime, strategic beneficiary planning, timing distributions across the 10-year window, but they require planning in advance and they cannot be done after the fact. Now, I want to share a different story with you. Richard and Helen came into my office when they were both 68. Their children had encouraged them to come. They had a revocable trust, good for probate avoidance, but nothing designed to protect against long-term care costs. Over a few weeks, we did a full overhaul. We transferred their home into a Medicaid asset protection trust, starting the 60-month look-back clock. We updated beneficiary designations on their retirement accounts. We worked with their financial advisor and did a Roth conversion on a significant portion of Richard's IRA, paying the taxes while Richard was alive at his rate, so the Roth account would pass income tax-free to his kids. We put comprehensive healthcare documents in place for both of them. 7 years later, Helen developed Parkinson's and needed memory care for 4 years. Richard stayed in their home, which was protected in the trust. Helen's long-term care insurance covered the first years of her care. When it was exhausted, she transitioned to Medicaid. Because the home had been in the trust for more than 5 years, it was not subject to estate recovery. When both Richard and Helen had passed, their 3 children received an inheritance within a few percent of what Richard and Helen had intended to leave them at the kitchen table meeting a decade earlier, despite 4 years of memory care costs. This is what the right plan looks like. Not magic, not loopholes, the right legal structures put in place at the right time. And the difference between Michael's family and Richard and Helen's family was not wealth, it was not luck. It was one conversation and the decision to act on it. So here's what I want you to do after you watch this video. 1, have a real conversation with your parents about their plan. Not about money, about protection, about making sure what they intend to leave actually gets there. 2, if your parents have a will or a revocable trust, do not assume the job is done. Bring those documents to an elder law attorney for a review. A revocable trust does not protect against long-term care costs. A will guarantees probate. There may be significant gaps. 3, if your parents have retirement accounts, talk to their financial advisor and an estate planning attorney together about Roth conversion planning and beneficiary strategy. The 10-year rule under the Secure Act is not going away. 4, if your parents have not done any planning, call an elder law attorney this week, not this year, this week. The Medicaid Asset Protection Trust 5-year look-back clock starts the day you act, and every year of delay is a year of protection you cannot get back. And if you're a financial advisor watching this, your clients need to hear this. Please share it. In nearly 30 years of practice, I've sat across from both kinds of families, the ones who planned and the ones who didn't. The families who come to us early almost always protect what they intended to protect. The families who wait or assume everything is fine because they have a will often don't. I've put together a free guide called Save Our Home. It walks through how families can use legal planning to protect their home and savings from long-term care costs. There's a link in the description below. It's completely free. Download it and share it with your parents tonight. And if you're ready to have a real conversation about your family-specific situation or to discover more, visit us at roulettelaw.com. If this video surprised you, if the numbers hit you differently than you expected, please share it with your siblings, with your parents, with your financial advisor. The family that needed to see this video 5 years ago may be someone you know. So subscribe for a new video every week. I hope you found this video helpful, and I look forward to seeing you in an upcoming video and the masterclass. Be well.